We're going to talk to you about today is what's going on in 2025 in patent litigation. And the short answer is there's a lot going on and some important stuff you need to know about. First, we'll get started on the next slide with introductions. My name is Sharif Jacob. I'm a partner at Keker, Van Nest, and Peters, and I've been doing patent litigation for almost 20 years. I serve as lead counsel in intellectual property disputes, and I practice before the district courts, before the ITC, before the PTAB, just about anywhere that you can litigate patents.
I'm Lynn Joyce. I'm also a partner here at Keker. My focus is on IP litigation. I do a mix of high stakes, copyright, patent, trade secret stuff. I've represented a wide variety of tech companies from Netflix with Sharif to Comcast with Ryan, to Zscaler and more in significant patent litigation across the US.
Morning, my name is Ryan Hayward. I'm an associate here at the firm. I likewise focus my practice on intellectual property litigation. I've been with the firm for around 5 years, currently focusing on a number of advertising technology patents. Have a background in product management, in ad tech and consumer technology. And thanks for taking the time.
Let's cover the agenda for today. We're basically going to have three main topics. First, we're going to talk about filing trends in 2024 and what we expect for 2025. Then we're going to turn to legislative developments that could affect patent litigation. And finally, we'll end with a lightning round where we cover a bunch of new developments in a short amount of time. Let's start with filing trends. Filings surged in 2024. In 2023, filings were down a little bit, but as you can see on this slide, in 2024, filings were up, and that's true whether it was NPE filings or suits by operating companies. In 2024, suits by operating companies constituted a higher percentage, 38%, of overall patent suits than in any of the prior years shown here. Where are people filing lawsuits? The oldies are still the goodies, I guess. So the Eastern District of Texas and the District of Delaware were the top two jurisdictions for filing. You can see that in this slide on the left-hand side, the gray bars. Okay, but NPEs had a slightly different preference. They wanted Texas and they filed more in Texas. So for NPEs, the Eastern District of Texas was still the leader, but the Western District of Texas was the #2 jurisdiction for NPEs. And for operating companies, slightly different. They filed mostly in the District of Delaware, and Texas is at the bottom of this list of 5. Which individual judges across the United States are still getting the most patent cases? And I think we're going to see some familiar names here and maybe one new name for some people. The bottom line is those judges are all in the Eastern District of Texas and the Western District of Texas. Judge Rodney Gilstrap still is getting by far the most patent cases of any individual judge. He's in the Eastern District. He's followed by Judge Schroeder, who's also in the Eastern District. And then he's followed by Judge Jordan, also in the Eastern District. Judge Albright, who used to have quite a higher percentage of cases, is still in the top 6. And just after him is Judge David Counts, who we're going to talk about a little bit later. Let's talk about sort of venue, how we got here, and the current state of the world. This is probably a refresh for some of us. For some of us, it might be new. In 2017, the US Supreme Court issued a decision in TC Heartland, and it limited venue for patent litigation. Okay? And venue for a U.S. company in patent cases, according to the Supreme Court, is proper only in the district where the defendant resides or has committed acts of infringement and has an established place of business. So that, when that decision came out, that limited patent venue because a lot of companies didn't have an established place of business in the Eastern District of Texas. Okay, so what happened? Well, a bunch of businesses had their headquarters in Austin. Judge Albright was appointed in 2018, and he began traveling the country, explaining why the Western District of Texas, and in particular his courtroom, was a favorable place for patent litigation. And so he surged. And for a while, he was the leader and was getting the most patent cases. There was some backlash. There was a bipartisan letter from 2 senators sent to Justice Roberts about forum shopping and single assignment districts. And is that really a good thing? Should we really be doing that? Justice Roberts issued a statement saying, no, we shouldn't be doing that, and then tried to issue a rule that turned out not to be enforceable, saying you shouldn't do that. In response, the Western District of Texas changed. Okay, then Chief Judge Garcia said, well, all patent cases are going to be randomly assigned among the 12 Western District of Texas judges. There was a new chief judge, and that decision was affirmed. And meanwhile, the Federal Circuit and even the Fifth Circuit are issuing a bunch of mandamus decisions, transferring cases away from the Western District of Texas to venues where the companies had their headquarters or otherwise had a place of business. Okay, but something new on the next slide is happening in the Western District of Texas. Judge David Counts, he is the Western District's new second most popular judge for patent cases. Patent plaintiffs are seeking him out, and well-known and well-respected plaintiff side patent firms are filing cases in front of Judge David Counts. Why are they doing that? Because he is a single assignment district. He is the only judge in Midland, Odessa. So if you file in the Midland, Odessa division, you are guaranteed to get Judge Counts. And that order that we talked about in the last slide that was issued by the chief judge, it doesn't apply to Midland, Odessa. So notwithstanding the various reforms we talked about, there is a way to get a particular judge. And let me tell you about a few of Judge Counts' practices. He has adopted Judge Albright's local patent rules. He is Judge Albright, after the order came down from the chief judge, he offered his patent specialist magistrate judge, Derek Gilliland, to the other judges in the district to preside over pretrial and patent cases. And Judge Counts has taken Judge Albright up on that. So now in the Judge Counts case, as a matter of course, you'll normally have Judge Gilliland presiding over a pretrial. And the other thing that's quite interesting is Judge Counts periodically transfers cases to Judge Albright. So I think for those reasons, patent plaintiffs are seeking out Judge Counts in the Western District. Let's talk about the top 5 patent verdicts in 2024, and there are some doozies here. Unsurprisingly, the top 2 come from the Eastern District of Texas. In 2 cases before Judge Gilstrap, General Access Solutions versus Celco, $857 million, Netlit versus Micron, $445 million. Judge Selna presides in the Central District of Texas. He is a well-known judge with a lot of experience in patent litigation. And the next 2 largest judgments belong to him, $315 million and $262 million. And then Judge Andrews, also, well-respected as a patent specialist in IP Technologies versus Microsoft. There was a judgment of $242 million. The first case and the 5th case on this list have settled, but the middle 3 cases, there are post-trial motions pending. So possible some changes in those verdicts. I'm now going to turn it over to my partner, Katie Lynn, to talk about legislative developments.
Thanks, Sharif. So I'll talk about what we're seeing on the legislative front beyond the courts. I'll cover a few bills that are floating around in Congress, as well as what we are seeing in terms of the changing leadership at the USPTO. Starting with the Prevail Act, this is not yet law. It is working its way through the legislature. Congressman Ken Buck of Colorado initially sponsored this bill in the House. He got co-sponsors from both parties, and then it was introduced in the Senate in July 2023 by a group of senators, again across party lines. The purpose of the bill is to reform the PTAB by increasing barriers to invalidity, so making it harder to invalidate patents through IPRs and other PTAB proceedings. It has passed through the Senate Judiciary Committee on a razor-thin vote of 11-10 in November of last year, and it's now subject to full debate before the Senate. So let's talk about what changes in particular we would see if the Prevail Act is enacted. So right now, in the PTAB, the standard for invalidity is that the petitioner must establish invalidity by a preponderance of the evidence. That's just more likely than not, 51%. If the Prevail Act is enacted, then petitioners will have a higher burden to carry. They will have to satisfy a clear and convincing evidence standard, which is the same as what applies in district court. In practice, the lines between these standards are mushy, but the higher standard at a minimum would give the PTAB yet another reason to deny petitions. And where there's disputed evidence, petitioners may run into real problems in terms of establishing invalidity. The second change is another significant one. Right now, no standing is required to file a petition for review in the PTAB. The Prevail Act would change that. When the bill was first introduced, it said standing is those who have been sued or threatened with suit. There was then debate about whether that was too narrow, and through a manager's amendment, 2 additional categories were added. The first is those engaged or planning to engage in conduct that reasonably could be accused of infringing. This one is obviously risky because at a minimum, the petitioner would be admitting that they reasonably could be accused of infringing. So, we'll see whether anybody actually relies on that as a basis for standing. And the second additional standing provision is for tax exempt nonprofits. But again, whether this one would actually be usable is unclear because it comes with a lot of hitches as to what relationships are permissible between the nonprofit and for-profit companies. So entities such as Unified Patents may not even be able to rely on this provision, but remains to be seen. The third change applies to estoppel. Right now, as many of you know, estoppel applies after a final written decision has issued. So if you petition for an IPR and it is not instituted, no estoppel applies. You can still pursue written prior art in the district court. This Prevail Act would flip that, and so estoppel would apply the moment that you file a petition for IPR. The fourth change is right now invalidity can be addressed by both the PTAB and the district court. Under Prevail, not anymore. The PTAB review is not available if there has been a final judgment addressing validity for that patent. And then last on this list is right now the same PTAB judge that institutes a proceeding also presides over those proceedings. This is meaningful because to get an IPR instituted, you have to show a reasonable likelihood of success. So a PTAB judge who is willing to find that you've established a reasonable likelihood of success is presumably more likely to also rule in your favor at the end of the day. But under the Prevail Act, it would switch hands. So once the petition is instituted, a different judge would then preside over the proceedings. All of this, added up would make it, I think, significantly more difficult, or potentially significantly more difficult, to establish invalidity through PTAB proceedings. Let's talk about another piece of pending legislation, the Restore Act. This one was first introduced in July 2024, and then just last month, it was reintroduced in the new Congress. The point of the Restore Act is to add just one sentence to Section 283, specifying that if a court enters final judgment finding infringement, then the patent owner is entitled to a rebuttable presumption that the court should grant a permanent injunction. What does this mean? It obviously increases the threat of a potential injunction at the end of a case. What led to the Restore Act? On the next slide, we can see the genesis for this act was negative reactions to a 2006 Supreme Court case called eBay. In the eBay case, a district court jury found eBay liable for infringement of Merck Exchange's patent. After the jury verdict, the district court denied Merck Exchange's motion for a permanent injunction. The Federal Circuit then reversed and applied a general rule that courts should issue permanent injunctions against patent infringement absent exceptional circumstances. The Supreme Court said no, vacated the Federal Circuit decision and said there's no general rule requiring injunctions, and instead a 4-factor test should be used, assessing irreparable injury, adequacy of remedies at law, hardship between the parties, and public interest. They sent it back. But there was not universal agreement on whether that was the right decision. And you can see here what Senator Coons thinks about the eBay decision. He said, quote, "Thanks to a wrong-headed decision from the Supreme Court," and goes on to explain why it should be easier for patent owners to get permanent injunctions. This, again, is not yet law, but we'll see what happens over the next several months. Next, PIRA. This is a bill that has been floating around for a while. This one is also not currently pending, but there is speculation that it will be introduced. It was first introduced in 2023. It was withdrawn in November 2024. And the stated purpose is to, quote, "restore patent eligibility to inventions across many fields." What does this mean in practice? Bye, Alice. The PIRA Act would take us back to the dark ages, before Alice, before Mayo, back to when Section 101 was a much, much harder thing, if a thing at all. More specifically, as you can see on the next slide, PIRA would eliminate all judicially created exceptions to patent eligibility. It would recognize any invention as eligible so long as it is a, quote, "useful process, machine, manufacture, or composition of matter, or a useful improvement thereof." Extremely broad view of eligibility. There are a handful of exceptions spelled out in the PIRA Act, which are here on the screen. They include a mathematical formula that is not part of a qualified invention, mental process performed solely in the mind of a human being, an unmodified human gene, an unmodified natural material. And then the last one, which seems to be the broadest of the exceptions, is a process that is substantially economic, financial, business, social, cultural, or artistic. bottom line, if PURA is introduced and reintroduced and becomes law, it would drastically change the landscape for section 101. Just a brief overview of the new USPTO leadership. On the left side of the screen is Howard Lutnick. He was confirmed as Secretary of Commerce, which oversees the USPTO last month, February 18th, 2025. I ordinarily would not include the Secretary of Commerce, but Lutnick has over 400 patents to his name. He largely in the banking and financial sector. And given his background, there's some speculation that we may see a greater level of involvement from him than we ordinarily would see from that role. And then on the right is Trump's nominee for director of the USPTO, John Squires. He is currently a partner at Dilworth Paxson. He's previously a partner at Gibson Dunn and Perkins Coie, and he has substantial IP experience, both in terms of licensing and acquisitions and some litigation.
My partner, Katie Lynn, has been talking about potential legislative developments. Now we're going to change a little bit and talk about some actual regulatory guidance that has been issued that impacts IPRs. And we're going to start just with a little bit of background on discretionary denials. So, as you all know, parties can file a petition for inter partes review and send the patent back to the patent office, and you can say you got it wrong. Never should have issued this thing. This is invalid over paper art, and there's some other grounds too. But those petitions, and then of course the trial has to be instituted or not, and it can be instituted or not on the merits. But there's another basis on which an IPR petition might not be instituted, and that's called a discretionary denial. That has little to do with the merits of whether or not the patent is invalid or not, and we'll actually talk about that relationship in just a second. But discretionary denial is when the petition gets denied because there's parallel litigation in the district court. And the notion there is we want to preserve our resources, and there's no point in two bodies reviewing the validity of a patent on the same grounds at the same time. That's the thinking behind discretionary denial. And it debuted in a decision called Apple versus Fintiv. And there's a bunch of factors you've got to consider. And we call those now the Fintiv factors for discretionary denial. Okay. On the next slide, we see that under the prior administration, the PTAB issued some Fintiv guidance, and it was issued by a former USPTO director, Kathy Vidal. And bottom line is that this guidance made it easier to overcome a Fintiv rejection, or it ensured that you were less likely to be denied on discretionary grounds. And this 2002 memo said a few things. It said, we, the PTAB, will not issue Fintiv denials where the parallel proceeding is in the ITC. It only applied to parallel district court litigation. This guidance also took, oh, no, we'll stay with the last one for just a second. This guidance also took a skeptical view of trial dates. Kind of before this guidance, and actually kind of well before, because decisions had already started to catch up to this a little bit. Parties were arguing, well, the district court judge set a trial date a year and a half out, and that's going to happen, before this IPR. And what PTAB learned was, oh, those dates don't always stick. In fact, they get kicked a lot. Even in the faster jurisdictions, they still get kicked. So what this decision said was, well, you can present evidence of the time to trial statistics generally, and they're going to look at that, and maybe they might give less support to the actual trial date, especially if those two things don't match up. Okay. Director Vidal also said Sotera stipulations are dispositive. What's a Sotera stipulation? Sotera stipulation is where you, the petitioner, file a stipulation with PTAB, and you say, once the decision is instituted, I'm not going to assert the same invalidity grounds as in the petition or any that could have been raised in the petition. A Sotera stipulation has the effect of transferring estoppel from the final written decision to the institution. And as is obvious, that helps ensure that the PTAB and the district court are not reviewing the same grounds at the same time. Okay, and then finally, Director Vidal said, well, if there's compelling evidence of unpatentability, we won't issue a discretionary denial. Okay, so now all of a sudden the merits matter on a discretionary denial, and it worked. Okay, this guidance caused discretionary denials to drop off, leading to higher institution rates. Now we'll go to the next slide, and on February 28th, 2025, the acting director of the PTO, Coke Morgan Stewart, issued guidance rescinding the memo that we just talked about. Okay, and after that came out, there's been some sort of news and speculation, including by me, about what this what rescinding this guidance means. Well, now we know, because on the next slide, we got some guidance from the Chief Administrative Patent Judge of the PTAB explaining what the rescission of former Director Vidal's guidance means. And he has sort of explained in concrete terms how things are going to change under the new regime. And so first of all, this new guidance that came out applies to any case pending an institution decision. So if you haven't got an institution yet, then this guidance applies to you. And now the ITC is up for grabs. So they're going to apply the FinTIF factors to ITC actions. And that means that if you're an ITC case, wow, you better get that, you better get that petition filed lickety split. And it's much more likely that you're going to lose on discretionary denials because, ITC cases move so quickly. And the PTAB also said a soteris stipulation is highly relevant, but not dispositive. So under Vidal, you file a soteris stipulation, it's dispositive. Now it's highly relevant. There was some case law from the PTAB on this, and the case law was pretty good. If you filed a soteris stipulation, it wasn't a guarantee, but there was a very high chance that you were going to get it instituted in the face of a FinTIF challenge. So soteris stipulations are definitely still the way to go. This guidance also said you get to consider any evidence about the trial date. So you get to consider the actual trial date that's been entered, but you still get to consider, the median length to trial. And then the PTAB can consider the merits, but compelling merits are not dispositive. So even if you've got a slam dunk winner IPR petition on the merits, you can still lose institution on FinTIF. And I've got some more updates as of yesterday. Okay, so as of yesterday, PTAB issued yet another memo that talked about the procedure for how this new guidance is going to be implemented. There's a new interim procedure at PTAB. And what's going to happen now is that FinTIF decisions and merits decisions for institution are going to be bifurcated. There's going to be two separate decisions made, and the FinTIF decision will come first. So the FinTIF decision will now be made by the director in consultation with 3 PTAB judges, okay? And that's going to precede a decision on the merits. If they decide that a FinTIF denial is inappropriate, then the IPR petition will be assigned to a regular 3-judge panel as it's currently done now. And how are they going to implement this? They've implemented a new briefing regime that's focused just on FinTIF. So you file the IPR petition, and then you get the notice that it was received. After that, and before the patent owner's preliminary response, there's a round of briefing on FinTIF only, so that they can make this new threshold determination. So, I predict that discretionary denials are going to go up, and they're going to go up significantly. And I also predict that as a result of this change in guidance, patent litigation is going to be up in 2025. So now I'm going to turn it over to Ryan to get us started on the lightning round.
Thanks, Sharif. So next, we're going to move into our lightning round, where we'll highlight a few of the most interesting recent developments in patent litigation and patent case law. So first up is Federal Circuit Rule 36. So of course, the Federal Circuit hears appeals related to patent litigation, among other matters within its jurisdiction. Its procedural Rule 36 permits that court to affirm district court judgments as well as agency decisions without any written opinion in certain circumstances. So for example, Rule 36 allows that court to affirm decisions of the PTAB, the Patent Trial and Appeal Board, without issuing a written opinion, and that court has in fact regularly done so. The practice is controversial among some, unsurprisingly, among litigants who expect to be provided with reasoning for why they've lost before the Federal Circuit. And there's also criticism from legal commentators who argue that the court failing to issue written decisions hinders the development of patent law. And opposition to Rule 36 took on, I'd say, a bit more fervor with the Supreme Court's recent decision in Loper-Bright last term, which overruled the longstanding Chevron doctrine from administrative law. And that doctrine had given a significant or extensive deference to agency decision-making, whether it was the PTAB or other agencies. Now, under Loper-Bright, the PTAB and other agencies are given significantly less deference. And so there have been arguments raised by opponents of Rule 36 that written decisions would help to ensure that the Federal Circuit is in fact closely scrutinizing agency decision-making rather than granting a sort of silent deference that's no longer permitted under Loper-Bright. So that's all just to set the stage to point out that there were two closely watched cert petitions pending before the Supreme Court, and the challenging the Federal Circuit's use of Rule 36. And in the end, earlier this week on Monday, the Supreme Court actually denied those cert petitions. And so Rule 36 is safe, at least for the very moment. Of course, denials of cert petitions are non-precedential, and the Supreme Court did not provide any reasoning as to why they denied these particular petitions. So there could be any number of reasons, and we should all watch the space. Further challenges to Rule 36 may very well come. Next up in our lightning round is some interesting developments in the case law of Section 101 before the Federal Circuit. For those who are not particularly familiar with Section 101, I'll just give a very high-level overview. It defines the scope of inventions that are eligible for patenting in the United States. And again, at a very high level, patents may only be obtained for new and useful processes, machines, manufacturers, and compositions of matter. And as will become relevant in these cases, I'll talk through patents directed to abstract concepts, for example, are not eligible for patenting. So the first case we wanted to highlight here is the Estelas case. And what happened there was the district court below had issued a ruling that certain of the plaintiff's pharmaceutical patent claims were invalid under Section 101, but the defendant actually never filed a motion or otherwise asked the court to issue a ruling under Section 101. So in other words, the court acted sua sponte. The plaintiff appealed to the Federal Circuit, and the Federal Circuit reversed, holding that the district court should have only ruled on issues that were actually presented to it. So the lesson here, pretty obvious, but good to keep in mind, is that if you're a defendant, you need to diligently raise your Section 101 defense and don't count on the court doing it for you, because they definitely no longer can. Turning to the broadband case next up, here in Broadband versus Amazon, the Federal Circuit continued what's been a pretty consistent and repeated line of cases in recent years, holding that digital advertising patents, specifically targeted advertising patents, are directed to an abstract concept of making advertising more targeted. And I think it's interesting that even though these patents involve ostensibly complex digital technology for a modern world, the Federal Circuit has analogized to the fact that marketers have always tried to make advertising more targeted, whether that's in the radio or over print. And similarly, in the last case here, the Savvy Dog case, this affirmed the ineligibility of patent claims that were directed to, quote, an electronic gaming system that previews the game to the player before the player commits to playing, where the preview would reduce, and this is the important part, the role of chance in relation to the role of skill. And so here the patentee had asserted in the litigation that the role of skill was important because certain states prohibited gambling games, but permitted skill-based games. And the court, in finding that this patent was ineligible under Section 101, highlighted the fact that the invention under its own description was directed to a concept for overcoming legal obstacles. And the court found that this was an abstract concept and therefore was patent ineligible. So I think the lesson from Broadband and Savvy Dog is that even where you've got these patents that are dealing with modern complex technology, consider whether there's an opportunity to analogize to abstract concepts that we all know from the offline world. Next up in the lightning round is Ecofactor versus Google. So the Federal Circuit acting en banc is currently considering a closely watched appeal by Google arising from its patent infringement trial with Ecofactor. So for context, Ecofactor sued Google in the district court before Judge Albright in the Western District of Texas, obtained a $20 million judgment at a jury trial. And at trial, Judge Albright admitted over Google's objection, the testimony from Ecofactor's damages expert, who assigned a royalty rate to the licenses at issue in the case by relying on Ecofactor's unilateral assertions in separate, purportedly comparable agreements that were not at issue between Google and Ecofactor in the case, concerning the existence and amount of royalties. And Google objected under Rule 702, Federal Rule of Evidence 702, and Daubert, which of course limit expert testimony to that which is based on reliable methods. Among other things, the expert's testimony must be based on, quote, sufficient facts or data. So Google appealed from the judgment, setting the stage for potential clarification from the Federal Circuit about what these words mean. What does sufficient facts or data mean under Rule 702? And so this appeal has potentially broad implications for the gatekeeping standards that courts need to employ with respect to expert damages testimony in patent actions. So oral arguments were recently held about a couple weeks ago before the Federal Circuit. At the argument, there was some focus on this broader legal question, which has, again, potentially important implications, but there was also a significant amount of discussion by a number of judges about a potentially narrower resolution, which would involve remanding to Judge Albright to consider under existing legal standards whether the expert's testimony was reasonable, sufficiently supported, and non-speculative. So the Federal Circuit may issue its opinion at any time. Watch this space. Next up is some developments that have dramatically expanded the ITC's jurisdiction. So the ITC, for those who aren't familiar, it's the International Trade Commission. It's a federal agency that has limited jurisdiction, now less limited jurisdiction, to enforce alleged acts of unfair competition, including patent infringement. So to establish jurisdiction in what's known as a Section 337 investigation before the ITC, a complainant has to demonstrate the existence of a domestic industry related to the patented matter. And there's two prongs for the domestic industry test. There's a domestic economic prong and a technical prong. And the two cases that you see here coming out of the Federal Circuit in the last couple months are focused on the economic prong. And the reason why before I get into these cases, the reason why the scope of the jurisdiction of the ITC matters is that there's two benefits from bringing in action, or key benefits bringing in action in the ITC. One is very much expedited proceedings as compared to a district court litigation. And then second, the potential to block the import of infringing goods. So The two cases that recently expanded the domestic industry scope under the economic prong are Lashify. So in Lashify, this stands for the proposition that US-based economic activities that are ordinarily associated with importers, such as sales, warehousing, and marketing, can be alone more or less sufficient to satisfy the domestic jurisdiction requirement, even if, say, no manufacturing is happening in the United States. So that's pretty interesting. And then secondly, in Wuhan, that stands for the proposition that even a company's very small investment in the United States in terms of dollar amounts can satisfy the domestic industry requirement, even if that company is, say, doing most of its business outside the United States. So the bottom line here is the Federal Circuit's recent action has expanded the potential opportunities for claimants before the Federal Circuit, and then likewise as a corollary, that's expanded the surface area for potential defendants to have to defend in the ITC. And with that, I'll turn it over to Katie Lynn for the next lightning round item.
Yes, I can talk briefly about what we think is coming in terms of AI guidance as applicable to patents under the current administration. At this point, it's like reading tea leaves because not much has happened quite yet. But the context for this is that last year, the US PTO issued inventorship guidance for AI-assisted inventions. That guidance recognized that inventors are likely going to be using AI tools more and more as part of their invention process. And they say, okay, yes, that's going to happen, but inventorship will still require substantial human contributions in order to qualify for patent. It is unclear if Trump will revoke or modify this prior guidance. A recent executive order that came out in January was focused generally on the concept of removing barriers to American leadership in artificial intelligence. It set out a number of steps that are being taken by agencies to investigate how to implement the order, and we will see what happens in terms of AI guidance for patents, but it's certainly something that we will all want to keep our eyes on.
Before I turn to double patenting, I'll just address the comment. There's a comment for those of you who haven't seen it that says, hey, maybe 101 is doing too much work in the life sciences field, especially given the upfront investment that has to be made in the drug developments. And I hear that. I've heard that from life sciences friends, and I've heard that from certain academics. I think what you hear from people who have been the target of software patents is that there's a lot of low quality software patents that are being issued by the PTO. And there's got to be some way to manage those. And you're right, 112 is doing a lot of work in the life sciences field. Amgen, 112 does almost no work in software cases because of how the standards have evolved with respect to that. So I think you are pointing out, an interesting place in the industry where there are diverging views and diverging experiences. And I think some of that debate is what's driving the legislation that Katie Lynn was talking about earlier.
I'll just confirm that and appreciate the comment, Janet. The legislation appears to be largely the PURA Act, which was introduced, back in 2023. It's now been withdrawn, but it appears to have been largely driven by concerns among life sciences companies. And it's broader than that in scope, but that appears to have been what led to its introduction in the first place. So you're not alone in having this view.
Okay, now let's turn to double patenting, which oddly enough has been a hot topic now for 2 years. Let's go back to the last slide because I'm just going to explain double patenting for those who are not as familiar with it. Double patenting is a really powerful doctrine that allows you to say, not only is this patent invalid over somebody else's invention, oh, this patent is invalid over my own prior patent. The doctrine of double patenting turns your own prior patents in the chain into a prior art. So it's an incredibly powerful doctrine in the limited applications when it applies, and those applications are when you have a second patent that is literally the same invention as one you previously made, or non-statutory double patenting, which is mostly what we're going to talk about, and that prohibits claims in later expiring patents, often the children of parents, that are not patentably distinct in the first patent or the parent. And during prosecution, sometimes you'll get those rejections, and you can overcome them by filing something called a terminal disclaimer. A terminal disclaimer says, this is my continuation patent, and yes, I know that normally the term of this would extend beyond the parent, but I'm going to disclaim that term. I'm only going to claim term up to the parent, and that overcomes rejection for double patenting. So let's turn to the next slide. And a couple of years ago now, there was a decision that significantly expanded the power and scope of double patenting. And I'm not going to go into it in super detail because many of you may be familiar with it, but what it basically said is you've got a child patent, and that child has a patent term adjustment that causes the life of that child patent to extend beyond the parent, and there is no terminal disclaimer, then that patent is invalid for double patenting. And wow, I mean, that means that now you need to ask all of your lawyers when you get a new patent case to just check every patent. It's a pretty quick check. It's easy to do, and you can determine pretty much from the face of the patent and a quick look at prosecution history whether or not the patent is invalid on its face. The more recent development came last year on the next slide, and an argument was made that double patenting applies in the reverse direction. Let's say you've got a parent, and the parent's term goes beyond that of a child. Does double patenting work in reverse? And I think for kind of obvious reasons, it doesn't. So the parent cannot, parent gets the patent term adjustment. It's not going to be invalidated by the later child. And those are the topics that we've got for you today. We welcome any questions if you've got them. And if not, we'll let you take a break until the next one. Okay, well, thanks everybody for your time, and enjoy the rest of the CLE.
Thanks, everyone.
You.
What we're